Ladies and gentlemen, my name is Myung Hwan Kim, a prosecutor of this case of Fletcher and Morris versus the state of California, and then I will show you, the points and argues, and conclude. The theme of the case is actually this one. Simply suggesting character evidence will not automatically erase that the people have conclusively proved by other evidence that the defendants are guilty of murdering beyond a reasonable doubt. Defense maybe claim this one first. So this one is confession implicating a co-defendant is generally speaking prohibited. Here, Edwards was confessing that the two defendants' crime, but they may say that statement could not be admitted to the trial, but that's wrong because here Edwards was not defendant. So this general principle, confession implicating co-defendant, is not applicable here. So defense cannot claim this principle. And let me show you the relevant legal principle and also jury instruction that is called the corpus delicti. It's kind of complicated, looks complicated, but let me explain to you. A defendant said something out of the court, made an out of court statement which is implicating a crime. So then whether the court could admit that statement or not, that is the issue of this corpus delicti principle. In order to admit that out of a court statement into the trial, there's another jury instruction here, meaning there should be other evidence. There should be other independent evidence which shows the crime really actually committed. The reason I'm introducing this one is here Edwards confessed in which two defendants committed the crime, and actually there is another evidence from Green, who was a bystander. And so actually corpus delicti is not strictly applicable here because Edwards is not defendant in this matter, but nonetheless that principle is very analogous to this case, to analyze this case, because one person, almost a de facto defendant, confessed out of a court statement, and then there is another evidence from Green. So so I can introduce that principle, corpus delicti, and I can progress more about under that principle. Please see this one. Actually, under corpus delicti, Mr. Green and Green and Edwards testified about these three defendants, and almost identical. So those Green's testimony and Edwards' testimony was almost identical. That almost identity is very rare in statistics. So that's one big point. And also Green's show up identification, he also identified almost immediately and almost identically with Edwards' testimony. Actually, under corpus delicti, other evidence does not need to show the identity of the defendants. But here, not only Green's testimony showed that the crime was committed, but also that the defendant's identity, which was almost identical with the testimony of Edwards. Defense side may claim, they show the character evidence here from Sampson. Sampson said he's friends with Fletcher and Morris, and he referred Edwards as having a bad character, thus raising discredibility of the Edwards' statements. And the person said, Sampson said, nothing bad about the police officers was ever heard from Fletcher or Morris, even on July 15. July 15 was the person visited the apartment, and no gun was ever seen from with them. So their defense side introduced this character evidence. So we, prosecutor should rebut this character evidence. Let me show you about the jury instruction about character evidence here. That jury instruction says, yes, evidence of a defendant's character could be introduced and could create reasonable doubt, which a prosecution should rebut. And defense continually would claim Edwards' discredibility and Edwards' inconsistent testimonies. He, as you know well, Edwards lied 2 times. First time at the station on July 16, and second time before the grand jury, first grand jury on July 19. And in both, he negated knowing the crime. But later, after cooperation, he changed his mind and he confessed. And further, per Sampson, Edwards was there on July 15, but Edwards said he did not get back to the department since July 2nd. So, the 2 statements were inconsistent. So maybe Edwards were lying. But that's okay. That's okay. You see? There is a called harmless error test, meaning court will apply this test. Yeah, Edward was a liar. He made a inconsistent statement, but that's okay. That mere discredibility of his character and inconsistency does not negate the proving beyond a reasonable doubt by identically matching with the testimony of Green. So that's core issue of this claim. Further, defense could claim there is no search warrant and arrest warrant. Defense could say Edwards permitted the search of his apartment, but actually the target was not his room, actually their room, because that apartment was a 3-bed apartment. And also police arrested the 2 defendants without an arrest warrant, and police also further searched the department subsequently without the warrant. But that's fine, because all these are warrantless exceptions. First, the police arrested them not in the apartment, but the 2 defendants were, just got out of the department, and then the police identified the 2 defendants per fitting the given descriptions. So they, the probable cause happened at that moment, so they could arrest lawfully in a public place, not inside of the department. Inside of the apartment, and then after removing from the apartment, the subsequent search was lawful without the search warrant. So all these are exceptions were applicable. All these are fine. And defense side could claim the show-up identification was unlawful because defense attorney was not accompanied in the show-up identification. Show-up identification was done during July 26th. That day, actually, defendant was two defendants was arrested. So that day, they was not charged yet. So meaning the show-up identification was a prior charge show-up identification, meaning there is no requirement that an attorney should be accompanied in the show-up identification. So it was okay. So again, the conclusion, the bottom line is, ladies and gentlemen, this one. So bottom line is the almost identical consistency of Edwards and Green's testimonies about the defendant's crime and identification surpassed the character evidence beyond a reasonable doubt. So the two defendants should be found guilty of murdering the Officer Kane, as evidence shows so and justice requires so. Thank you, ladies and gentlemen.